Welcome everyone to Dishwasher Diaries, where we discuss all topics integral, tangential, and most of the time utterly irrelevant to the very controversial subject of loading the dishwasher. Our very special guest today is the wonderful Dahlia Lithwick. Dahlia is senior editor at Slate. She hosts the Amicus, if we listen to Justice Breyer podcast, and she is an all-around maven on all things Supreme Court. We'll talk about that, but we'll talk about some other stuff as well. But before we do any of that, I will play, and you're hearing it for the first time, Dahlia, our wonderful theme song.
Do you wash by hand or by machine? Do you rinse your dish or do you leave it in the sink soaking?
We have matching glasses, Dahlia.
Dishwasher queries.
Not eyeglasses, drinking glasses.
People all over the world. Bring your questions then.
That's good.
Come and meet my friends. Dishwasher Diaries. Have you ever cleaned out your food trap? Have you ever researched all the brands of the product you're using? We will investigate the best way to dry your plates. Bring your questions then. Come and meet my friends. Dishwasher Diaries. Dishwasher Diaries.
Welcome, Dahlia. How are you?
That was something. I might want to hear it again.
Well, we're going to play it again at the end, so you might get a chance to hear it again. So here's where I've got to start, right? As a former Supreme Court clerk, and you being one of the foremost commentators on the court, people would think that that might be how we met. But of course, the truth is, we met over dishwashers. So before we talk about the Supreme Court, you sent me a note once saying visiting Dishwasher Diaries changed your life. So that's where we've got to start. What happened?
We met because we were in peak COVID. I had two teenage sons who were failing utterly to abide by the cardinal rules of dishwashers, both loading, unloading, dishes in the sink. I had just placed a flow chart, do you remember this, over my sink that was essentially like, if that's this, then this, if that. It was like a NASA space launch. It was so complicated. They were mad at me. And then you had some devotees, slavish followers, who I was a slavish follower of them. And then we all were slavish followers of you. And then somehow through the alchemy of dishwashing, you solved all my family's problems and we've never fought again.
Amazing. So let's go back to the flow chart. Okay. You prepared a flow chart for your two sons about how to do the dishes. And this includes, where does it start? Does it start with clearing? Does it start at the sink? Where did the flow chart start?
It starts at the sink. I think I tried at some point to photograph and upload, but at that point also it was, I think, operating in 3 dimensions, maybe 4. Like, it was not a usable document. In the fashion of lawyers, it had codicils, it had footnotes, it had like reference back to original drafts. And I had posted it over the sink because I was so aggrieved that my sons just seemed to be of the view that dishes wash themselves and that the dishwasher loaded and unloaded itself. And they were, And I think you may or may not recall, but I had one Chaos Muppet kid and one Order Muppet kid. And so it was really causing immense friction. Like our Order Muppet kid was rewashing all of the, anyway, it was terrible. And the flowchart made things immeasurably worse in my family because it was like a passive aggressive lawyer mom flowchart, like worst solution ever.
And I want to ask about the two Muppets, but first the flowchart one. So the flowchart was like where to put things in the dishwasher. Did the knives go in this way or that way? Like what sorts of things did it cover?
There was a shouty opening sort of section, like think of it as the Declaration, where it was like, stop. If you are throwing a thing in a sink, make better choices. And then it was like, open the dishwasher. Is it dirty? If so, is it full? You know, like, again, everything.
So it was like emptying it out into the garbage. Does it need to be rinsed? Does it go on the top? Does it go on the bottom? All that kind of stuff.
All the things. And also, like, if you open the dishwasher and it's full of clean dishes, there's really no decision to be taken other than empty it. There may have been like a silent "you jackass" in that section. And my children, who are like lovely in almost every way, but they do not like when like I do shit like that at all. So that was when you entered into my life. And I don't remember. I put them both on the phone with you.
It was unbelievable timing. The way it happened, as I recall it, you were in the car with your husband and one of your two sons, I think the Order Muppet.
Yes, good, excellent, that's true.
Right? And Chaos Muppet was at home. And the call actually started while you were all in the car, continued as you went up to your place, and then we got your other son into it, and we had a whole conversation. If I recall correctly, he didn't agree 100% with your characterization of the situation.
But he was an 18-year-old boy, to be sure. I mean, he hasn't agreed with my characterization of the situation for 14 years. But yes, but you did personal interventions.
We did. We chatted.
I don't understand. Like, you actually, like, did a personal crisis intervention for two surly teenage boys who were not really all that psyched about, like, bearing their souls on Clubhouse to a bunch of strangers.
It was awesome. Thank you. I'm going to take that as flowers. So thank you for the flowers. I love that I can make a small contribution to harmony in the Lithwick household. We're now regrettably going to turn to a somewhat less mirthful topic. And that is, of course, this Supreme Court term. I want to talk about specific cases, but I want to talk about some general themes first, because I feel like we have only so much time, and I feel like we could dive into all of the cases, which we will do. Well, some of the cases. Youch. And then never get to some big themes. So I want to start with a few big themes. Maybe we'll circle back to some more at the end. But I've taken, and I'm not prone to hyperbole, I've taken to describing this Supreme Court term as lawless. That is the word I've been using. Because I just think the degree to which the court did 180-degree turns or 150-degree turns on prior law, not just in terms of overturning opinions, but just taking bizarre, sharp turns, is unprecedented. So that's where I want to start. Your thoughts on that?
No, I think that's completely correct. And I think one of the byproducts of that is really actually very serious is that we are accustomed, you and I, to having two of those cases a year. You know, like we had one Bush v. Gore, and then the court just chilled out for years, right? We had Citizens United, everyone went crazy. We, at the very, you know, I've done this for 22 years. I think in the craziest terms, we might have had 2 or 3 big ticket holy hell, what just happened cases. And partly, I think because of that, we got so hyper-focused on Dobbs, the abortion case, maybe on Bruin, you know, maybe the EPA case, that your sort of initial point is descriptively correct, which is there were 12 of those, you know, there might have been 14 of those. And it's almost impossible. It's hard enough to integrate what happened in those 3-4 big ticket cases that grabbed all the headlines. But that means we also missed what happened in the Native American, jurisdiction case. We totally missed, I think, the cert grant, the decision to grant a case that came in the last seconds of the term that is going to be the most consequential elections law case that we ever. And so I guess it's my way of saying that it's always been a critique of mine of the way we cover the Supreme Court, that we hyper focus on 2 or 3 cases a year. And we often miss, and really law dorks will tell you, that there can be hugely consequential, like civil procedure cases that change pleading standards for all time, and we just miss them. And this was a term where there were so many. I mean, lawless is probably a generous description, just so many, I would say, nihilist decisions. And because we only can kind of take in 2 or 3, we haven't even had a public reckoning about not just how lawless those 2 or 3 were, but how really terrifying the whole big sweep of the term was and what's coming next.
And there's so much to cover there. And I want to get into some of the specifics you just mentioned, but I want to stick with big themes a little longer. The framing of it, as someone who covers the court, and I assume a large percentage of your audience are people who are reasonably well-versed. Maybe they're lawyers, maybe they follow this stuff. But obviously, you're appearing on MSNBC and popular media. You're writing for, Slate and other publications. A broad audience is reading your work. The way the whole conversation gets framed, I think, as a disservice, right? It feels to me like, this is just a debate between 2 competing philosophies, this thing called originalism, which sounds like it makes sense to me. It's both philosophically and practically utterly bankrupt. And this other theory of a living constitution where things evolve. And, it's really just a symmetrical debate between 2 different visions of the Constitution. I think this sadly misrepresents what is happening up there right now.
I think that's right. I think you've probably heard this too, but one of the enduring things I have heard in the last few weeks is, how could this happen? How could this have happened? How could the court have just gone this far off the rails? And what that tells me, sometimes when I'm feeling grumpy and sleepless and cynical, that my initial knee-jerk response is, how did you not see this coming, right? I mean, if you heard the oral argument in the abortion case in December, if you read the leaked draft in May, nothing about what happened the last week of June should surprise you. And in fact, the court had functionally already done it on September 1st with the Texas SB 8 law. So I think that sometimes I get a little frustrated that it seems that this all happened in plain sight, in slow motion, and we didn't clock it. And I think there's lots to say about how that happened. But I think the most generous version is that there is so much myth-making and magical thinking around the courts that people who are trying to reckon with what just happened this term and how singular it was have to almost unlearn so many ideas that we accept with like quasi-theological, acceptance. And I use the word theological quite deliberately, and we can talk about that. But I think that there is a way, I did a podcast last night with someone who said, but I always learned that the Supreme Court was completely neutral. And I was like, wait, did you learn that on Schoolhouse Rock?
Balls and strikes, right?
It's amazing the degree to which all of us, including, by the way, incredibly savvy, con law professors, just completely internalized all of the propaganda around, balls and strikes, around, originalism as some kind of like coherent, doctrinal interpretive method as opposed to, ends driven. Like, we can talk about every piece of it, but I think, this was a total Wizard of Oz term where suddenly the curtain gets peeled back and it just is abundantly clear that we have 6 political operatives who were seated on the court in order to do by way of the judiciary what could not be done in a legislature, and to moreover ensure that future voters could not in fact control what happens in a legislature. It's a pretty simple, like, the plan is not complicated. We are seeing it at its fruition. But I think that in order to see that, there is such an immense amount of wishful thinking and magical thinking, but they love the country and they're patriots and they're just doing law, and this is a mechanical, oracular court, that puts aside their predilections and it was never that. There's been maybe 5 minutes in the history of the court that it has met that aspiration. It's always been political. It's always been, with very few exceptions, revanchist and backward-looking and conservative. And I think that in a weird way, the work now is to kind of explain that all that stuff that you thought was true of the court was what you needed to accede to in order to accept the court's power.
Wow, that's interesting. So we're asking a lot of the audience because we haven't dived into the details of any cases, but that's okay. I want to stick with this. I have 3 different illustrations, and this is from 3 different cases of the activism of the courts, because I think part of it is the substance being lawless, and part of it is the approach. My first example, I want to start with the 2 religion cases, and in particular, the Maine case. So just to summarize it for our audience, Maine has a very far-flung population. There are lots of rural school districts where there literally is no secondary school. So the legislature passed a program that essentially allowed parents to direct a subsidy payment to a private school so that students living in a district that didn't have a secondary school could go to one with some of their tax dollars being deployed toward it. But they excluded schools that were teaching religion. It wasn't enough, as I understood the statute, Dahlia, it wasn't enough that it was simply affiliated with religion. If it was a school that was like at a Presbyterian church, but you didn't learn Presbyterianism, you could get the money. But if the school was teaching the religious faith and inculcating a particular religion, you couldn't get the money. But what I want to focus on to start, and it's on your point, Locke v. Davey, a case that obviously you're going to be familiar with, but which I'll describe to the audience, was a 2004 case. Only 18 years ago, the Supreme Court was faced with a case involving a scholarship for students to major in theology in college. A scholarship that was generally available, and it excluded theology majors. In a 7-2 opinion written by the Chief Justice, Rehnquist at the time, joined by Stevens, O'Connor, Kennedy, Souter, Ginsburg, and Breyer, very short opinion, didn't find it to be a particularly difficult case, does not violate the First Amendment to exclude theology. We don't have to dedicate tax dollars to training people to become ministers. The only 2 dissenters were Scalia and Thomas. A mere 18 years later, I think the case is essentially not distinguishable. It is college versus secondary school, but I think it's basically the same case. 18 years later, total reversal. They have 1 paragraph. They distinguish Locke by saying, oh, that was about training people for the ministry. It's lawless. It's just, we know the result we want. We'll pretend to distinguish a controlling case and just do what we want.
Sorry, I've muted myself. That's exactly right. And maybe I'll take one step back just for folks who aren't First Amendment scholars and just say, to the extent that this helps you sort of think about the issue, there's 2 sort of religion clauses in the First Amendment, and they push in opposite directions, right? One is what Steve just talked about, that there is this establishment clause that says, we will not have taxpayer-funded religion. That it, in fact, is the law. That the state does not, endorse or promote religion. And that, as you just heard, it has been the law for decades that public education is not used to inculcate sectarian religious values. And the framers would say they believe this very strongly. That is why they fled Europe. They fled Europe because in countries that had a state-sponsored religion, and by the way, in the colonies, where you could get burned literally for being a minoritarian faith, it is too dangerous to have a state church. And then there is pushing in the opposite direction. There are this religious liberty claims, right? That you are free to exercise religion as you see fit. That is a private enterprise. The state cannot in any way encumber you from expressing and exercising your religious faith. And there's a million contexts in which obviously those are on somewhat of a collision course. And for decades and decades, as you just heard, the court has sort of lived on the seam of those two things, trying really hard to protect religious liberty and to say that, you will not have your religious liberty encroached. And at the same time, to avoid having state religion that is forced on minoritarian faiths. What we have essentially seen in the 2-decade period since Locke v. Davey and since the other cases that have said, Lee versus Weissman, all the cases that say that you cannot have state tax dollars fund sectarian religions, is that the religious liberty claims have swallowed everything. And I know we're going to talk about the praying football coach in a second, but essentially religious liberty claims, now everything else is eviscerated. And that has been a drumbeat that we've seen in a whole bunch of different contexts. In some sense that was right. That was Hobby Lobby, where the religious liberty claims of corporations to not give abortion, what they believe to be abortion causing drugs, to their employees who are of different faiths, swamped the statutory guarantee of birth control, right? We are seeing that in case after case after case. We're about to talk about the football case. But essentially now, if you think about those COVID restriction cases, which, by the way, the court decided on their shadow docket, which is something else we should talk about. The court essentially said, we will set aside state public health declarations about capacity limits on places of worship in peak COVID. Why? Because religious liberty claims are more important. And maybe the best way to say this is Catherine Franke, who teaches at Columbia Law School, said this on my podcast, Amicus, this week. We now have first-tier rights, which are religious liberty and guns. And everything else is second tier. And so a good way, I think, to think about Carson, which is the case you've just described, is it is now claimed as a violation of religious liberty of the parents who want to send their kids to explicitly sectarian religious schools. It is religious discrimination is the word that the Chief Justice keeps using, to not give them taxpayer funding. And maybe just the last thing I'll say about this case, because I think it goes to your point about how lawless it is this case builds on a case called Trinity Lutheran, in which what the court looked at was a rubber surfacing program that gave kids old rubber tires to put on the playground so they wouldn't scrape their knees. In Trinity Lutheran, when the claim was it is discriminatory not to give that to sectarian schools, Chief Justice John Roberts writes an opinion saying this is just about playground materials. This is not going to go farther than this. Exactly. And he says he's cabining it to just making sure that kids don't get injured on playgrounds. And now it is cited as authority for the proposition that you are discriminating against religious schools if you do not give them taxpayer dollars. So going forward, I think the very, very, very short takeaway is everybody who wants religious institutions to get taxpayer money now has a claim that they are being discriminated against if they don't get it. It's called the sort of most favored nation status in the doctrine, and religion always, always wins.
I agree totally. And I'll add one thing to build on what you said, and that is, as it's pointed out in the concurrence, there's this notion that the free exercise clause and the establishment clause don't have to butt up against each other. What Justice Breyer, Justice Breyer says in the concurrence is, it might have been okay for Maine to decide to include sectarian schools. Maybe that wouldn't have violated the establishment clause. But what the majority is saying is, once Maine decides to give this money to help people pay for secondary schools in districts that don't have one, they must give the money to religious schools, right? Justice Breyer is saying, look, it is possible to live in a world where it doesn't violate the free exercise clause for a legislature to decide not to include sectarian schools, but it also doesn't violate the establishment clause to just make it available to all schools. But the majority on the court wants to dictate it, and I'm going to make both these points before you respond. The other is, you and I are both religious. Neither of us is Christian. We're both Jewish. And what I also find remarkable is this notion that Christianity is under attack in the United States, that Christian people are under attack. And the reason it's become, in your words, this preferred right is this notion, and I think it's the same with guns. They want to take away our guns and our Bibles and our churches. And so these are the rights that are most at risk in America today and need to be protected. Not racial discrimination, not civil rights violations by police officers and other government officials, these are our two biggest problems. This is where the court needs to step in and take extraordinary action. Very bizarre.
I mean, I guess it's bizarre. I think the other way to think about it is that these are the rights and the prerogatives of, wealthy, white, land owning. Like, these are exactly the rights that, and I've used the word revanchist, I use it, quite advisedly, that those rights are actually more urgent than the Voting Rights Act, than the right to one person, one vote. Those rights are not serious, and the court has been whittling away at the right to vote through, voter suppression, through gerrymandering, through Shelby County and Brnovich, the decision last year that was the follow-on to Shelby. So I think there's no other way to look at this, and I'm trying to be fair, other than to say this is a court that is dealing with huge demographic shifts, that is looking at a country that is simply not sustainable as a country that privileges the interests and the values of Christian white men forever. And the way to ensure that which would be changed over, demographic changes and voting changes and geographic changes is arrested completely, is kind of strangled in its infancy, is to say that these rights, of property, of contract, the rights of religion, but only some religions, as you say, and the right to own guns actually have a superior status to other rights. And there, it doesn't bear saying, but we should just say the Bill of Rights isn't like a ranking, like the First Amendment doesn't actually outweigh the Fourth. The 14th Amendment is meant to have equal weight. And so I think that what we are really seeing, and maybe there's one other thing we should throw into the mix, which is the families who are going to suffer in Maine after that Carson decision are the families who have same-sex parents, whose children are gay, who will not be allowed to attend those schools, teachers in those schools who will not be able to teach their values. Like, this will fall hardest on vulnerable communities. Again, those are invisible in the majority opinion. They are not invisible in the dissent.
Yeah. So I want to stick with this theme of the various ways. This is the way I'm kind of stringing the cases together. The various ways in which the court acted illegitimately. The first was just ignoring an 18-year-old precedent and pretending they weren't overturning it and just swatting it away. In the other religion case, the case involving the high school football coach praying after the games on the 50-yard line, they used a different technique, among others, in all of these oversimplifying, of just changing the facts. I mean, this is a case where literally the majority opinion, the opinion for the court written by Gorsuch, I don't know any other way to say it. It just lies about the facts of the case. I mean, that's not the end of the analysis, but that's a little troubling.
My colleague, Mark Joseph Stern, who covers the courts at Slate, warned about a month ago to watch this case, the Kennedy case versus Bremerton, for exactly the reason you just identified. He said if the court swallows the factual record as it was presented by Coach Kennedy's legal counsel, then the court no longer cares about truth itself. And that would launch us into a whole new kind of Mad Max world where we're not even fighting about doctrine anymore. We are fighting about what is true. And maybe the best evidence of the point you just made, that the court, in the majority opinion by Justice Gorsuch, hook, line, and sinker, represented as factually true things like this is a private prayer. They kept saying it was a quiet prayer. It was only 3 incidents. This was a years-long pattern. Coach Kennedy was on television saying he was going to do this. And the court represents it over and over again as private and silent and quiet and not disruptive. And the best evidence that that is false is that Justice Sonia Sotomayor, in her dissent, affixes photographs. Like, she literally throws photographs from newspapers. Here is Coach Kennedy, surrounded by all his players, taking a knee, lifting a helmet aloft. This is not a private, silent, quiet prayer. This is a person who repeatedly was offered accommodations by the school that said, go pray here. We don't want to get in the way. I mean, again, these two clauses are in conflict, right? We don't want to get in the way of your religious liberty. Here are all these different ways you can do this that isn't on the 50-yard line after a game with students who are of different faiths who feel that they must pray with you in order to play next week. And the answer in Justice Gorsuch's opinion is that none of that happened.
Yep, it's frightening, like you said. Well, they do it on both sides. They ignore the law and pretend it isn't what it is. And if that's not the route they want to take, they ignore the facts and make the facts what they want them to be. We have so many to cover that I'm going to leave the religion cases there. I want to turn, I guess, next to Dobbs, the case overturning Roe and Casey. And there's so much to say. I guess, though, the place I want to start is, and this will enable us to have a little conversation about originalism, is we have a bunch of historians telling us that the court gets the history wrong. That begs the question, of course, in many cases, is there even a right answer, right? Should the Supreme Court be in the business? And I'm going to compound 3 questions here. Should the Supreme Court even be in the business of trying to figure out the history when that would normally be, like a 1-week symposium with 90 history professors, and they would all argue, and then they would probably say, well, there's lots of evidence on both sides, but who knows, right? In some cases, the history may be clear. In other cases, it may be very unclear. And forgive me, but I'm going to throw in a third one. This is my own personal theory. I didn't see this advanced anywhere. But Justice Alito focuses a lot on the fact that at the very least restrictive, there were laws on the books at the time the 14th Amendment was passed, making abortion illegal as of the time of quickening. Nobody made the following argument, as far as I know. It's a practical one. It's a pragmatic one. I read those laws. I looked at the record in the case. Quickening at the time was defined as when the pregnant person felt the fetus moving. And I just wondered, like back in that time when those laws were in the books, and a quick digression, this is a time when slavery was legal and women were fifth-class citizens, not second-class citizens. But put that aside for a moment. I wondered if a pregnant person went to the doctor and said, right, I want to get an abortion. Did the doctor just say, well, have you felt movement yet? And if people understood that that was sort of a prevailing rule in certain places, then the pregnant person said, no, I haven't yet. And the doctor said, okay, then we can proceed. So, right, they turned quickening into like some scientific line that would have been applied back in the 1910s, the 1920s, the 1930s. So 3 really complicated questions. I said a lot there. I'll shut up now and get some reactions.
No, I mean, I think I'll start where you ended, which is on quickening. And by the way, that line of demarcation that abortions, before quickening are permissible and after, are either impermissible or can be regulated. I mean, this doesn't just go back to the founding, right? Or the colonies. This goes all the way back.
And it's not that different than Roe.
No, I mean, Roe in a weird...
It's a few weeks different.
Yeah, Roe tried to codify what was essentially like a principle of law. Justice Alito cherry picks unbelievably. As you say, the American Historical Association just issued a statement saying like his history is crap.
Garbage.
And he cherry picked to the point of, shocking, unnatural, tortured readings. But I also think, it's useful to think in response to your quickening question, if for folks who like the podcast Slow Burn, this year's Slow Burn at Slate, the first it's all about sort of life before Roe and law before Roe. And one of the really chilling things that has been lost to history is the story of Shirley Wheeler. Shirley Wheeler was prosecuted by the state of Florida. And this is in the early 1970s. They used to say we only prosecute the provider. Shirley Wheeler went to jail. And the subject of the trial, in addition to her having an abortion, was whether or not there had been quickening. And in order to get her to be jailed, and I mean, friends, when I tell you that ultimately when she was sentenced, the sentence was she had to break up with the man she loved and go home to North Carolina and live with her family as though she was 60 years old. This is a woman in her 20s. But it's, I think, a really telling kind of case study because we're going to now see women prosecuted. It's not just going to be providers who are prosecuted. And that idea that you just lifted up, Steve, is so essential because she said there's a range of weeks for quickening. It's a squish test. And you had the coroner coming in and saying, oh, she was clearly 8 months pregnant. They ended up FOIA-ing the weight of the fetus. It was under a pound. This is the kind of stuff you can mess with really, really readily when you want to prosecute someone. And, Shirley Wheeler stands for the proposition that women will go to jail. And we're already seeing that, by the way. Brittany Pula in Oklahoma is serving time for fetal endangerment. We saw a woman in Texas arrested and then not tried for endangering a pregnancy. So this is where it's going. It's not going to be just doctors. It's not going to be just providers. It's going to be women themselves. But onto your substantive point, it is certainly the case that the history in Dobbs, which is shockingly untruthful, which cites with approval Sir Matthew Hale, somebody who, by the way, was for witch burning and invented the marital rape exception that said that you couldn't rape your wife because she was chattel. All of that stuff gets cited with approval. And what doesn't get cited with approval is the actual principles behind the 13th and 14th Amendment. Why it is that the 13th and 14th Amendment created the idea of privacy and autonomy. And I've been banging on and on about this, and I won't waste your time today. I will just say, go ahead and read Dorothy Roberts. Go ahead and read Peggy Cooper Davis. The reason the 13th and 14th Amendment protected family privacy, the ability to do with your body what you wanted to do, was because if you were an enslaved person, your wife could be raped, your children would be removed from the home, your spouse could be sold to someone else. Everyone was property. There was no right to determine who you married and what your family looked like. That is what the abolitionists who drafted the 13th and 14th Amendment were trying to codify, that never again could people use a woman's body for economic purposes or for pure breeding purposes. Never again could you be told how your children were raised. And the whole line of cases, Steve knows this better than anyone, that follow from the 13th and 14th Amendment, that you cannot be sterilized against your will, that you can use contraception, that eventually becomes Obergefell and gay marriage. That whole line of cases is because abolitionists were terrified of what would happen if women were treated as vessels. So here we are again, and that history is nowhere in the Dobbs opinion.
And I think that takes me to a quick question. I'm going to throw another alternate theory or point at you, the Thomas dissent, right? So the Dobbs opinion says over and over again, this is only about abortion. This should not be read to affect those other rights you just referenced, Dahlia. The access to contraception, sex in your home not being criminalized, same-sex marriage. This should not be read, and it doesn't touch any of those. Now, people usually bring up the Thomas dissent to make the point, and I don't disagree with this point. You've made this point. Don't be fooled. Those are all in the crosshairs. But the other point that I think the Thomas dissent makes powerfully, concurrence, it doesn't mean to make it, but I think it does, is that the majority opinion is completely unprincipled. Because as the dissent says, if the majority really believes its own reasoning, then it's nonsensical to say that it doesn't affect those other rights. The same reasoning applies. And so when Thomas says, I think we should look at Obergefell, I think we should look at Barrett, I think we should look at all these substantive due process cases, he is pointing out that the majority is just unprincipled. They just want to make abortion illegal, and they've manufactured a legal theory, and then they claim the legal theory doesn't apply to other areas where its logic frighteningly does apply.
No, that's completely correct. Yes. Thomas is saying the quiet part loud.
It's terrifying.
And I think that, there's two ways to think about it. One is that Thomas is saying the quiet part loud, that he's saying there is no principled basis to distinguish Obergefell and Lawrence and Griswold, and that those are on the table. And by the way, we're now seeing state actors in Texas and Florida that are going to go after Lawrence and Obergefell and Griswold. It's very clear. That was a roadmap. But I think the other thing that you're saying that really, really cannot be emphasized enough is that because there's no meaningful principle, and it goes to your lawless point, there is no meaningful principle by which they can be distinguished, right? And the dissenters call this out too. The dissenters also say, you're either lying or you're hypocrites. Like, it's pretty brutal. But because there's no principle by which Roe is just different, because we say it's different, that you now are getting a situation where you're supposed to take Alito's word for it, right? Alito's telling us, oh, this is different. Don't worry about those cases. We're not gunning for. And then Brett Kavanaugh, like the most fatuous concurrence in the history of concurrence, is also saying, don't worry, we're not coming for these other rights. But why would we believe people who just overturned 50 years of precedent with a sweep of a pen to say we're not coming for? Those are precedent. I mean, I think it's the most Lucy football performance I have ever seen in my adult life. And the idea that we're supposed to just take their word for it, that is precedent of the court and they're not touching it, as they're slashing and burning precedent in, as you've noted, 7 other areas, I think we should just be really, really clear that the idea that we're supposed to just trust them not to disturb other cases is so preposterous. And as I said, I think it's just really important to realize, like, around the country now, women are being refused the morning after pill. That is contraception. Women are being refused, help with getting IUDs placed because that is deemed contraception. This is not, we're gunning for Griswold. This is Griswold in some jurisdictions is already gone. And we should be really, really clear that when Sam Alito tells us it's safe, that is not worth the paper it's written on.
And this is just information. Most of our listeners will know this, but right, the idea that access was where it needed to be for a constitutionally protected right before Dobbs. I mean, right, Jackson Women's Health, I believe, was the only clinic in the state. So, I mean, the court and state legislatures had already done an enormous amount to restrict access to not only abortion, but all sorts of maternal related care. This was just the final, sort of death blow.
I think that's right. And I think I always go back to people like Professor Carol Anderson in Georgia, who comes on my podcast and reminds me that if you were Black and voting in America, you always stood in a line for 7 hours with your battery pack to charge your phone and your water. And if you were Black in America, you always had to travel for 3 days if you were lucky to find a place with a clinic and find a place to take care of your kids. And that if you were Black in America, you know, a lot of what we are trying to process now is lived life for many, many, many millions of poor, Black and brown, trans, gay, elderly students have always lived life this way. And so I think in one sense, this is the silver lining, and it's a pretty gray silver lining, but it's worth flagging that for people who thought Roe v. Wade was some inviolate gift of the right to an abortion, if you lived in Texas or Mississippi, you never had that right. And especially after the Hyde Amendment, you could never finance that right. And so there is a great leveling that's happening now where all of us are learning, like you don't just get to be sort of like fly by your drive-through voting station in Connecticut. You don't get to just, book a clinic down the street. This is how life has been lived for hundreds of years by a lot of people. And that maybe this goes to your opening framing, which I think is kind of apposite again here, which is the problem with all these fantasies and illusions about democracy and freedom and, we all have the right to vote and we all have all these rights, is that it was always so ephemeral to begin with. And that we made a kind of a collective delusional promise to ourselves that had to be true because otherwise it would be an intolerable juristocracy. But like a lot of that was just an intolerable juristocracy just for other people.
I like that. I want to stick with Alito to transition us to the gun case. And again, to briefly summarize, very simply, New York had a law that required most people, not all people, to show proper cause to have a concealed carry. You didn't need it to show cause if you owned a shop or various other things, but most people had to show cause. What the court essentially did, I think, is make pretty much all gun regulations presumptively unconstitutional unless you could prove, in the words of the majority opinion written by Justice Thomas, that, essentially it clearly would have been allowed at the time the Second Amendment was ratified, which of course is crazy for obvious reasons in terms of the way weapons have evolved and many other things. But I want to start with the Alito concurrence. And this is personal for me. This is not jurisprudential. You've won the case, right? You've got a majority that's going to gut the proper cause standard. Alito is so offended that Justice Breyer's dissent would start by talking about the scourge of gun violence in our country, homicide, suicide, mass shootings, that he essentially devotes his entire concurrence to just express his outrage that Justice Breyer would have the nerve to mention those things in his dissent, joined, of course, by Justices Sotomayor and Kagan. And to me, again, this is personal, it's not jurisprudential. It shows such a callousness to me. It's like ghoulish. It's not enough to win the case. It's not enough to make the Second Amendment, like you said, this sort of preferred right among all others, reading it in a way that is utterly ahistorical. That's not enough. you also have to take someone to task for talking about the dangers of guns in our society. I really felt sick when I read his concurrence.
Yeah, I reread the concurrence after Highland Park last week, after the shooting, because that callousness is so abundant. And maybe I can make 3 short, serious points. And I didn't quite answer your why are we doing history in the first instance question, so let me answer it now.
Terrific.
Again, the historians absolutely universally panning Clarence Thomas's history work in Bruin. This is the New York Guns case. There was bad history that undergirded Heller, which was the right to own a handgun in your home for your protection. It's been debunked. Even the bad history is now called out as bad history. And historians, there's not a lot of dispute that the historical claims that are being made by the gun owners in this case are cherry-picked and they are distorted, and that lots and lots of stuff is ignored to get to the end that Clarence Thomas wants to get to. So again, why they are doing bad history in lieu of, building constitutional doctrine, which was one of your framing questions. As Justice Breyer points out in his dissent, we're not historians. This is not our job. We are the worst ill-equipped people to do this. And the only thing we're worse at than history is doing public health. We're crap at that too. And as you said, Justice Breyer's initial couple of paragraphs are just ticking off the violence, the carnage, suicide, the domestic violence. And Justice Alito's like, who cares? And you're right. There is
not just who cares, but I'm offended that you brought it up. How dare you bring it up?
It goes to Adam Serwer's "The Cruelty is the Point." It also goes to the issue you raised around religion, which is that the justices have such solicitude for people like them. So people like that, like the solicitude that Justice Alito evinces in his concurrence is for the poor worker late at night on the New York City subways who's unarmed, and everyone else, it's the Wild West and everyone's like, boo, 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 boo. And this is the one person who doesn't have a gun. And that's who Alito's heart breaks for. And then he, as you said, Justice Breyer is days away from retiring, and on the way out the door, Justice Alito thinks it's appropriate to swat him on the nose like he's a jerk. So, in addition to those 2 semi-serious points, I want to make one deadly serious point, and that is, I think this connects back, and I think this is, if nothing else I say chills you. I think it connects back to SB 8, that Texas vigilante bill that started the term. And folks may recall on September 1st, without argument, without briefing, without any evidence, the court allowed Texas to have this law go into effect that allowed anyone in the country to collect a $10,000 bounty if they turned in somebody and civilly sued somebody who either had an abortion, provided an abortion, or wait for it, aided or abetted someone having an abortion, right? That's just straight up vigilantism. That idea that everyone in the country is now a law unto themselves undergirds so much of the doctrine this year. So we see the court being like, oh, who gives a crap what, a school board in Maine thinks about. They don't know. We know religious liberty. Who knows, what this stupid school board that was trying to determine and make an accommodation for Coach Kennedy. Bunch of middle managers. Who cares what the CDC thinks about masking? Who cares what the EPA thinks about pollution? What matters is you. What matters is the court. And the complete endless disparaging of government lawyers, of teachers, of the hundreds and hundreds of climate scientists who do work, of all of the public health officials who are trying to keep us safe in a pandemic. This is the stuff Alito loves to go after. This is the stuff Thomas loves to go after. And the deadly serious point I want to make, and I think it's maybe a good place to land, is that when you then massively expand gun rights, and you say Heller's no longer the law, it's not a right to own a gun in your home, it is a right to carry it. To fail to connect that to January 6th, to fail to connect that to Kyle Rittenhouse, to fail to connect that to, I think, a conservative legal movement that is trying to disassemble the administrative state, to disassemble the layer of lawyers and government public servants, all of it, and says that they're all just in on the grift, and then to arm people, that should scare your face off. It scares my face off.
Yep. This might have to be a part two, but looking forward, we didn't talk about West Virginia v. EPA, but you just alluded to the idea. It's not just about that one EPA regulation. And by the way, sticking with my theme, they didn't even need to take that case. They reviewed a regulation that was no longer being enforced. Again, another example of the extreme activism. But putting that aside, with regard to voting and just our democracy more generally and the administrative state, this seems to me to be the two areas that they want to strike death blows to next term. And maybe we'll end with whatever thoughts you have on that.
Yeah, I mean, I'll just quickly say that I think it's possible to feel so shelled by what happened in June that you want to kind of go on screen save. And you go on screen save at your peril, because already docketed for next fall, as you said, there's a huge Clean Water Act case that is going to also give the court really a chance to scupper environmental protection regulations and agency authority writ large. The affirmative action is on the docket. There's a challenge to affirmative action. I think it's clear. We have 5 votes to do away with affirmative action. We have a huge...
This is affirmative action just for our audience in higher education admissions, college admissions.
Yeah.
Sorry, go ahead, Dahlia.
And then finally, just, to end on the existential one, this case Moore, which is a case about the independent state legislature theory. That's essentially the theory that John Eastman and Rudy Giuliani were trying to peddle.
Got sanctioned for, basically.
That got sanctioned for, and that no court would have tolerated. Now the state of North Carolina is going to try to make that law. And if the court decides, and this is just very quickly on the merits, that a state legislature can absolutely do what it wants, not just with election proceedings, but election results, and that no court, state or federal, no governor, no state attorney general, no state figure whatsoever can intervene, then you are inviting ballots of fake electors in Pennsylvania and Wisconsin, the exact thing that they tried to put into effect in January of 2020. And so that case is such a sleeper and so hard to explain that people probably just slept through that 30 seconds. But it is existential, because that is the roadmap for setting aside the 2024 election.
I know you are out of time, so I'm just going to say thank you. I'll invite some folks up and I'll try to answer some questions, but we'll do this again. And when I come to New York, we're going to break bread. Thank you so much.
Thank you for having me. Take care, all.
Be well, Dahlia.
Bye.
Well, I wish I enjoyed that conversation very much, but it is sort of a frightening conversation. Chris, I don't think there's anyone on stage with us currently, and I'm so sorry we just got so deep into it that I didn't bring anyone else up to ask her questions. We didn't even get to ask her about her opinions of Supreme Court justices and their dishwasher habits, which I really wanted to do. But let's invite some folks on stage if they have questions. We'll talk a little bit more about what we were speaking about with Dahlia, and then maybe we'll speculate a little on the dishwashing proclivities of the various members of the court. And be warned, if you come up to ask a question, you just might have to answer a few questions yourself about your dishwasher routine at your home. How's that sound, Chris?
Good. It is, and as always, it is a safe space. So I see we have some new people here, and I would love to get them up.
And I'm going to go get my dishwasher magnet. I wanted to show it to Dahlia, but I just didn't find a good moment to get up. So while you're inviting someone up on stage, I'm going to go get my magnet, and I'm going to send one to Dahlia as a gift because she clearly needs it.
Oh, okay. Yeah, so I see that we've got a few new faces down there. I see a lot of our typical dishwasher gang there. raise your hand and I will be happy to bring you up. And we'll chat a little bit about dishwashers.
There
Oh,
it
that's
is.
funny.
This was a gift from one of our charter members of the Dishwasher Diary gang, Cindy. And I do use it, and I never accidentally put a dirty dish in with a clean load.
Well, for people that don't have the visual, we've got.
Oh yes, gosh, duh.
We've got it's a nun on either side of it, and it says, I can't read it from where you're at.
It says dishes are clean and the nun is smiling, and it's blue background. And then when you flip it over, dishes are dirty, just like you, with a red background.
I love it.
Thank you, Cindy. I don't know if Cindy's with us today.
Ngozai has joined us, one of our stalwarts.
And Ngozai, how are you?
Oh, well, I'm depressed after that conversation.
It's seriously, I mean, I'm not prone to hyperbole in these matters. I do think it's alarming not only what the court has done, but what they aim to do going forward. It's complete. Everything that the conservative judicial movement said they were against, so-called judicial activism, using their own personal preferences and their policy desires to decide cases. They're going against all of it. They're doing all the things they said they stood against in a way that they've never been done before. But sorry, go ahead. I interrupted you.
Just as I listen to these conversations, I realize it's so much worse than we think it is. Like, it's problematic all the way down.
It is. And of course, it's a 6-justice majority in most of these cases. Occasionally it's 5-4, but it's usually a 6-justice majority. And so, there needs to be a major shift in the composition of the court. One of the questions I wanted to ask Dahlia, we could have easily done 2 hours, was, what does she think about various proposals for structural changes to the court, adding justices, limiting their terms, having a retirement age, all of these various sorts of mechanisms to at least ameliorate the effects of an entrenched court that is both extreme and out of step with the mainstream. But we never got to that. Do you have any particular question in Ngozai? Or I can certainly understand just coming up to commiserate, but did you have any question?
I mean, save us? What do we do? That's a general plea. I don't know that it's actually an actionable question, but if you've got the answer or an idea, I'd love to hear it. Because the only apparent solution that I've heard has been just adding more members to the court. But if we're thinking creatively, is there anything else, or is that kind of our only option until people die, which they're pretty young. It's going to be a while.
I mean, as I've said before, I don't know that any of these things can get through Congress and get signed by a president. But the composition of the court and its jurisdiction are largely a function of statute. Congress determines that by statute. And so term limits, 18-year limits is a bill that is currently in the House. I don't know that it has any traction whatsoever. But I think short of adding justices to the court, which I think would be extremely unpopular politically, at least limiting the terms, 18-year terms is what's suggested in the current legislation, which would mean essentially that every president appoints 2 Supreme Court justices. It doesn't become so much of a gambit, blocking nominations as was done with Merrick Garland, retiring early to let someone else take a spot. At least you'd eliminate some of that. You might also eliminate appointing these judges who maybe are too young and are meant to be there for 30 years. But these are at the margin, and I don't know whether any of those are even practical. I think we're faced with a court here that's going to be dangerous for a decade or two. It's pretty. Do we have anyone else who wanted to ask a question?
Hold on, I think that there's somebody in there. It looked like somebody. There we go. Rick is joining us.
Hello.
Welcome, Rick. Now, I let Ngozi off the hook only because we've chatted a little with her before about loading the dishwasher, but I don't think in our podcast incarnation, I don't think we've had this conversation with you. So before you contribute on the Supreme Court front, are you the person who is primarily responsible for loading the dishwasher in your household?
No, we have a very democratic household here, and both Tara and I, and we're the only two in our household. We both load the dishwasher, and we actually discuss how to load the dishwasher. You
discuss it. Are there some disagreements in style that needed to be worked out, or is it just whoever loads it gets to use their style, or did you need to hammer out a consensus on certain issues?
We did need to hammer out a consensus, and it's funny because when we got married, neither of us had ever had a dishwasher before.
Oh, wow.
So when we remodeled our kitchen, it was our very first dishwasher, and we had to learn how to use it correctly.
And what were the points of contention? Was it how much you clean them before they go in? Which way to put the knives and forks? I mean, what were the differences in approach?
Yes, there was the haphazard approach. Do the bowls go on the top or on the bottom? Bowls are a problem in almost any dishwasher. Unless you have those kind of, flattish kind of large soup bowls. And that's what we end up doing most of the time when we have soup, is we use those large kind of flat ones. And they do actually go in the bottom where the dishes go and fit pretty easily.
Right, but those, I know what you mean, the sort of more glass-shaped bowls or cup-shaped bowls. Those are the toughest because, right, most people are going to put those on the upper rack, but they don't really always fit so great in the glass and cup channel on the ends. I think that thing in the middle is meant for them, the middle of the upper rack. Yes. But like you say, sometimes if they're too cup-shaped, they don't nest so well up there.
Now, our biggest bone of contention is I will occasionally, if I just have lunch and I just had a sandwich and the plate's not really dirty, it just has a few crumbs on it. Lots of times I will just run a little bit of water, wipe it off, and, put it on we have one of those kind of dish drying towels. Mm-hmm. And she does not like that.
Because she wants it to go through the dishwasher.
In the dishwasher.
Well, and that brings up the whole, we won't necessarily cover this since it's not your practice, but that brings up the whole group of people who basically wash the dishes before they put them in the dishwasher. And I don't mean just rinse. I don't mean just wipe with a sponge. I mean wash them so well that you could dry them and put them away. And then they just put them in the dishwasher as this sort of extra sterilizing step or something. We'll save commentary on that till we have a friendly viewer or listener that actually does it that way. but this is kind of nutty, I think, and a major waste of water. But you might have had something more substantive you wanted to say about Dahlia and the court and all of that.
I thought it was great. It was. I agree with Ngozi that it was a bit depressing. I would love a part 2 that's kind of solutions oriented.
Great idea.
Because really, there's no quick fix for this.
Yeah, I was thinking of, sorry to interrupt, I was thinking of more like, the court writ large. I totally agree with you. On individual issues, right, there is a variety, just to strike a positive note, right? Some of these issues can be addressed by state legislatures. Some can be addressed by state Supreme Courts. Some can be addressed by the executive, whether it's the president or a governor. So there are some areas where I think other institutions and individuals can act in a way that can change or ameliorate some of this. But in some areas, it's more difficult. I mean, when the Supreme Court says that a certain kind of law is unconstitutional, you can't just pass another version of the same law. So sometimes it can be navigated around, but in some areas it can't. And of course, sometimes, to add one other thing, sometimes the issues, the solutions are non-legal solutions. I mean, I think what we're going to see with regard to access to abortion and other maternal related health care is practical solutions, right? Even better access to medication abortion, making it easier for people to move from state to state if they have to, as horrible as that is. And I think there's going to be a set of on the ground practical solutions that are meant to at least ameliorate some of this. And as Dahlia and I talked about briefly, it's not like those are new. There were many states that already only had a single clinic or 2 clinics. There were many states where under Casey, there were already burdensome rules and laws that made it more difficult to access the care. And so organizations involved at that level have already been doing this, but now, of course, they need to quadruple their efforts. I'm sorry to interrupt you, Rick.
Yeah, I mean, really, basically what they are basically doing is saying they want to remove power from the federal government, which means the Democrats, who have been woefully good, woefully bad at getting out the votes for state houses and governorships all across the country. And this is really where we have basically 8 years before the next census and the next redistricting. And if we don't start getting Democrats and even moderately progressive independents get that vote out in mass across the country, gerrymandering that'll be the end of our democracy. I mean, well, they don't even call it they won't even call it a democracy anymore. They say we're not a democracy, we're a republic. That's the new talking point. And that
one just drives. I mean, I hate to sound so partisan, but to me, that is like a quintessential example of some of what passes for logic on the far right, as if saying the words, "We're a republic, not a democracy," are actually a justification for or a rebuttal against the criticisms of voter suppression, taking away minority rights, etc. I mean, it's brainless. I don't know another word for it. It's just brainless. We all know that we have a democratic republic. Labeling it as a republic versus a democracy isn't a substantive argument. It's like a 4th grade talking point. It's just silly.
But anyway, she was fantastic. That was a great. It was a great Dishwasher Diaries.
I'm glad you enjoyed it. Well, I always like to end with a full dishwasher interview. Thank you, of course, to the wonderful and amazing and insightful Dahlia Lithwick. Thank you to Chris Seacott, my wonderful producer. Thank you to the entire Dishwasher Diaries gang who joins us live. And by the way, if you're listening to this as a podcast or you're watching the recording on Fireside, you can join us live and become part of the conversation. Just join us on Fireside. We record live. We have a live audience, so please join us. And finally, thank you to Brother Sam Lange, who wrote and performs our wonderful theme song, which I will play for you again now as I bid you a good day. Take care, everyone. Louder. There we go.
Do you wash by hand?
I'm singing along.
Or by machine? Do you rinse your dish or do you leave it in the sink soaking? Dishwasher queries from people all over the world. Bring your questions then. Come and meet my friends. Dishwasher Diaries. Have you ever cleaned out your food trap? Have you ever researched all the brands of the product you're using? We will investigate the best way to dry your plates. Bring your questions then. Come and meet my friends. Dishwasher Diaries. Dishwasher Diaries.
Say it, Chris.
Dishwasher Diaries was recorded before a live studio audience.
Take care, y'all.
Created live on Fireside.